Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, earlier this week, we did this video right here where we were talking about two cases that are now being distributed to conference before the United States Supreme Court. The Harrell case out of Illinois, the Bianchi case out of Maryland. Potential to have the United States Supreme Court finally, once and for all, decide the legality of assault weapon bans. And I got to tell you, it's not coming a moment too soon. Because at one time when we were covering some of this litigation, the arguments that we used to get from those that support civilian disarmament were kind of comical. They were kind of farcical. It was kind of a good little chuckle. But lately, these arguments have turned downright evil, downright nasty, and I'm telling you, if the United States Supreme Court were to ever adopt any one of these positions, well, none of us would have an inalienable right of self-preservation anymore. Don't believe me? We're going to go out to Connecticut and I'm going to show you a prime example. So today, let's spend a few minutes and let's talk about the very dangerous arguments being made in support of assault weapon bans. Okay, so here's the case we're talking about today. It's in Connecticut. It's the matter of Grant v. Rovella. It is currently before the United States Court of Appeals Second Circuit after coming out of the United States District Court for the District of Connecticut. It is a challenge to both Connecticut's assault weapon ban as well as their large capacity magazine ban. The plaintiffs had originally asked for an injunction of that law. The trial court threw the plaintiff's claim out on its ass. And so they have now appealed to the Second Circuit and are asking for the Second Circuit to take another look at it. Now, I said at the outset of this video that, the arguments that we're beginning to see on these issues, they're getting downright dangerous. And let me just give you a flavor of what the state of Connecticut is saying. And let me also preface that all of the dangerous arguments that I've seen, a couple over here and a couple over there, well, all of them appear in this one memorandum here. And that's why I want all of you to pay very careful attention, because you're going to start seeing these arguments pop up everywhere, including before the United States Supreme Court. But just to give you a flavor, this is how the state of Connecticut sees the issue. The Supreme Court has already said that states may ban M16 machine guns and the like, and the AR-15 and other restricted weapons are like their military siblings in every relevant way. Muzzle velocity, maneuverability, ammunition, rapid fire rate, damage inflicted on the human body. Because they are unusually dangerous weapons of war, neither used nor useful for self-defense, the restricted assault weapons fall outside the Second Amendment's presumptive protections. That's right. The state of Connecticut, with a straight face, is arguing that these are offensive weapons that are more appropriate for military use, that they cannot be used for self-defense, and therefore they're not even protected by the Second Amendment. But this argument gets way, way more troubling than that. What I'm going to go through is several of the arguments that they're making to show how those that are supporting civilian disarmament are literally making up case law out of thin air. And what's worse than that is we are actually seeing appellate courts buy off on it. Did you guys know that there was a new common use test? I didn't either. I kind of geek out on this stuff all the time. But according to the state of Connecticut, this is how the common use test works. Plaintiffs are unlikely to succeed on the merits because they did not meet their threshold burden of showing that assault weapons are presumptively protected by the Second Amendment. That meant showing that the restricted weapons are in common use today for self-defense and not unusually dangerous weapons of war. And again, this is all news to me. I always thought that the common use test would kind of be defined by the number of items that are actually in circulation for lawful purposes. But no, the state of Connecticut says that's a red herring. We should not even be paying attention to the numbers. They actually make this argument. Plaintiffs did not even try to carry that burden. In an inquiry about the historical understanding of constitutional texts, plaintiffs put nothing in the record from either historians or experts in textual analysis. Instead, they adduced a handful of imprecise statistics aimed at tallying the number of assault rifles owned or in circulation. And listen, they doubled down on this argument that if we're talking about common use, the number of items that are lawfully owned and in circulation does not matter. They argue, again, plaintiffs brush all this history, text, and precedent aside, trying to carry their burden with ownership statistics alone. Their numerosity argument failed below and fails now, for several reasons. No constitutional right hinges on mass consumption or social popularity. Now, and again, arguing that the numbers don't matter, the defendants here, the state of Connecticut, points out what an argument that we talked about in this video right here, one that is supported by case law, one that is supported by the numbers, but one that the state of Connecticut doesn't want to deal with. But they do point out plaintiff's numerosity argument would implicitly overturn Miller and Heller, throwing the 1934 National Firearm Act's constitutionality into question. As of 2021, the last year for which data is publicly available, over 741,000 machine guns were registered in the United States, far more than plaintiffs' proposed 200,000 benchmark for common possession. And of course, that common possession benchmark comes from the case of Catano v. Massachusetts, again, Supreme Court precedent, not really cited in this memorandum, but then again, when you're creating case law out of thin air, it's kind of hard to come up with citations. Now, here's another troubling argument they're making. They're saying, hey, listen, we banned all sorts of things in this statute. And if you're going to strike this law down, that means you're going to be striking every part of it down, including some things that we clearly can ban. So because some of these things we clearly can ban are constitutional, you can't throw any portion of this law out. They actually argue, because plaintiffs bring a facial challenge, they have an even heavier threshold burden. They must show that Connecticut's gun safety laws are unconstitutional in all applications. But the laws restrict weapons, features, and accessories like grenade launchers and street sweeper shotguns that the Second Amendment plainly does not protect. So plaintiffs fail even if some of the restricted weapons fall within the constitutional ambit. Well, that's an interesting angle to take, because then state legislators could just start drafting, ban all sorts of stuff, and then let's make sure we throw in, rocket launchers and F-15s and M1 Abrams tanks and things like that. And because that's permissible, it means that everything else that's banned in there is permissible. Now, although I thought the plain text of the Second Amendment was really clear, and many of you believe the same thing, I guess we've been misreading it the whole time, because the state of Connecticut points out the plain text protects only keeping and carrying arms for self-defense. The Second Amendment, Heller taught, codified a pre-existing right of law-abiding residents to possess and carry weapons in case of confrontation. Not any sort of confrontation, though. Instead, the 1689 English Bill of Rights explicitly protected the right to keep and bear arms for self-defense. So to understand what our founding fathers meant when they drafted the Constitution in the late 1700s, let's go back and take a look at what the British thought of inalienable rights in the late 1600s, remembering that there was a reason we declared our independence from them. Oh, here's another one, the dangerous and unusual test. Now, we've talked about that 100 times on this channel, and listen, while almost all firearms are in fact dangerous, really where the rubber meets the road is unusual. Now, that's going to be based upon the scarcity of the item, how frequently are they in circulation, how many Americans are using them for lawful purposes, or so I thought, but apparently the state of Connecticut sees it differently. Plaintiffs must also show that a restricted weapon is not a dangerous and unusual weapon falling outside the Second Amendment's protection. Historian Cornell explained that the founding generation would have understood dangerous and unusual as a figure of speech meaning unusually dangerous. Well, that may be the case, but that is not what the case law says. Nice try. But ultimately, and this is the big danger in all of these arguments, is that at some point, courts are going to start buying off on this. And if we ever lose control of the United States Supreme Court, it will be the highest court of the land. And what's going to happen then is that the court is going to be able to dictate, in their opinion, what they believe is appropriate for your self-preservation. As the state of Connecticut argues with a straight face, the restricted weapons are unusually dangerous, just like the M16 military rifles. They are used more often for mass shootings than for self-defense, and they are designed and marketed for offensive combat. The restricted assault weapons are indistinguishable from bannable military weapons. Start with the place where the Seventh Circuit ended. Assault weapons like the AR-15 are indistinguishable from military weapons like the M16, and states can restrict both. And then finally, I know what many of you are wondering. Where does all of this come from? Are they really that stupid? Are they really that naive? Or are they just trying to be creative? Well, I'd like to say that that's probably the case, but unfortunately, well, the state of Connecticut pulls the veil back here, because where all of these disingenuous arguments come from is out of pure hatred for you and your lifestyle and your willingness and desire to exercise liberty through your inalienable right of self-preservation. Don't believe me? Well, this is what they wrote. Plaintiffs have not even tried to make their requisite showing. Their only alleged hardship is a claim that they cannot keep themselves safe pending trial without wielding multiple redundant weapons of war. But each plaintiff already owns well over a dozen firearms, including rifles, pistols, revolvers, shotguns, and others that work just like otherwise banned assault weapons. As you can see, they are telling you what is appropriate. Now, you think that's a snide comment, you're true, but then you see the footnote, because here they are mischaracterizing all of these people as being a bunch of gun-owning freaks that got plenty of ways to defend themselves. But then you got to read footnote 15, which states, the precise number of firearms the various plaintiffs own is unclear, as they all testified that they were not sure, could not remember, or did not count how many firearms they own. And yet, why would you want to let that get in the way of labeling them as each owning dozens of firearms? The bottom line is, every vile, hateful argument that could possibly be made by those who support civilian disarmament are advanced in this memorandum through the state of Connecticut. These are all of the arguments that if any of our appellate courts, or if, God forbid, the highest court of the land were ever to adopt, it would be the end of everybody's Second Amendment rights. Listen, the case once again is Grant v. Rovella. We'll link it up down below so that you guys can geek out on it for yourself. If you got ideas for videos that we should be doing here at Washington Gun Law, go ahead and click on that link right there, because some of the best videos we ever did weren't really our ideas to begin with. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law. By now, if you don't, that's okay. That information is down there in the description box. And then finally, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.